Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to The View from Mayer Brown, our regular employment podcast. My apologies for the interruption in normal service. The truth of the matter is I had a week's holiday, and around that, and in fact during my holiday, and I'm not bitter and twisted in any way, we've been doing a load of work for clients on various injunction and other litigation matters. So it's been good fun but hard work, and sadly that just interrupted with the recording of the podcast. Anyway, we just had time to squeeze a podcast in during a gap in the work schedule, and so here we are. We got 3 cases, of course. I thought we'd look at the Egan Zender case on restrictive covenants, given it's the first Supreme Court case dealing with restrictive covenants in something like a century. We've got a case on whether it's discriminatory to pay men on shared parental leave differently from women on shared maternity leave. And finally, a really interesting case about sharing offensive images on Facebook. Please don't forget, the podcast, it's available via iTunes, it's on the Mayer Brown website, it's YouTube, the Twitter feed, and Spotify, Google Play and Yahoo. Okay, let's dive in. Ali and Capita Customer Management Limited, which was joined with Hextall and the Chief Constable of Leicestershire Police. This is the Court of Appeal decision in the ongoing and hugely important litigation on whether a comparison is possible for discrimination purposes between pay during periods of statutory maternity leave and pay for shared parental leave. As the Court of Appeal put it, the central issue in both these 2 appeals is whether it's unlawful discrimination on the basis of sex, either direct sex discrimination or indirect sex discrimination, or indeed because of the operation of the Sex Equality Clause, which is implied into all contracts by virtue of the Equality Act 2010, do either any of those routes get you to a position where it's unlawful for men to be paid less on shared parental leave than birth mothers are paid on statutory maternity leave. A little bit of background may help. Statutory maternity periods are provided for under the Employment Rights Act 1996 and the Maternity and Parental Leave Regulations 1999, which gives 26 weeks of ordinary maternity leave and 26 weeks of additional maternity leave. Maternity pay is available for 39 weeks, and the first 6 weeks it's payable at 90% of the mother's average weekly earnings, and then for 33 weeks it's payable at a fixed minimum rate. At the relevant time it was £138.58. Shared parental leave, by contrast, is governed by the Children and Families Act 2014 and the Shared Parental Leave Regulations. They allow a woman to bring her maternity leave to an end after the 2-week compulsory period following childbirth, and she may instead opt to take the remainder of her leave period under the shared parental leave regime rather than the statutory maternity leave regime. If that decision is taken, then the 50-week maternity period, or such portion of it as is deferred, can be shared under the shared parental leave legislation between the mother and her partner. Statutory pay during the shared parental leave period is the minimum of the lower of £138.18, or 90% of the partner's average weekly earnings. Well, the factual background to these cases was, as is relatively common, employers were voluntarily enhancing maternity pay but were not voluntarily enhancing shared parental leave pay. It was argued that since men were not taking statutory maternity leave and so were not benefiting from the enhancement, it was discriminatory if employers were not equivalently enhancing any shared parental leave period. Now, in terms of this litigation, Mr. Ali was claiming it was direct discrimination for Capita not to be paying him at the same rate as a woman on statutory maternity leave. Mr. Hextall claimed it was indirectly discriminatory. Mr. Ali won in the Employment Tribunal but lost in the EAT. Mr. Hextall lost in the Employment Tribunal and won in the EAT, to the extent that the Employment Tribunal in the Hextall case was asked to go back and have another look at matters. Everyone appealed. Well, certainly Mr. Hextall and his employer both appealed, and Mr. Ali appealed too. Because the cases clearly raised similar issues, they were then joined. Now, the Court of Appeal rejected the appeals by the individuals. In relation to the claim by Mr. Ali that it was direct sex discrimination, the Court of Appeal came to a fairly quick decision. They decided that the purpose of statutory maternity leave was to enable the birth mother to prepare for and cope with the latter stages of pregnancy, and then to recover from the pregnancy and childbirth process. The upshot of that was that this was a different process from shared parental leave. There were significant differences, the court said, between shared parental leave and statutory maternity leave, the purposes being one of them, and as such, the appropriate comparator was not a woman on statutory maternity leave, but the female partner of a woman on statutory maternity leave who wanted to take time off pursuant to the shared parental leave legislation. In those circumstances, a woman, female partner, taking time off under the shared parental leave legislation would have been paid at the same rate as Mr. Ali, and therefore there was no direct discrimination. Interesting, the court went on to say, or to confirm, that this interpretation, the direct discrimination argument, their views on the purpose of maternity leave were not limited to the statutory minimum period mandated by EU law, and in the UK leave period is slightly more generous. This was the purpose of maternity leave under the more generous UK rules too. So what about indirect discrimination? Well, I think the Court of Appeal had rather more to consider in relation to Mr. Hextall's claim, which was that it was indirectly discriminatory on the grounds of sex, unless objectively justified, for Mr. Hextall to be required to take off time pursuant to the shared parental leave regime, which was paid on a worse basis, because in practice far more men would be taking time off under that regime than women would be taking time off. Court of Appeal said that, in effect, Mr. Hextall's claim ought to be regarded as a claim for an equal term in his contract of employment with that of his comparator. However, the problem with regarding this as an equal term claim was that there's a statutory provision which says that the sex equality clause, this equal term clause, did not apply if the comparator's terms, in this case the birth mother's terms, were better because of special treatment given to the mother because of her pregnancy or for going through childbirth. Therefore, in effect, there was a statutory exclusion for Mr. Hextall's claim. In any event, the Court of Appeal considered that the Employment Tribunal had correctly rejected his indirect sex discrimination claim, even he had been able to proceed with that, because in reality what he was complaining about was that only a birth mother had the right to statutory or contractual maternity pay. So to that extent, it wasn't really a provision, criterion or practice. Moreover, said the Court of Appeal, and really just to put the boot in completely, my terms not theirs, it would have been justified for the employer to take this route of enhancing maternity pay but not shared parental leave period, and as such any indirect discrimination would have been justified because, according to the Court of Appeal, what the employer was seeking to do here in enhancing birth mothers' pay during the statutory maternity period was a proportionate means of achieving a legitimate aim. Court of Appeal also placed some significance on the fact that the right to shared parental leave was not a freestanding right. It was conditional on the mother agreeing to swap her leave. So the special treatment of mothers in connection with pregnancy or childbirth, which resulted in them being paid more, was a proportionate means of achieving a legitimate aim. Now, look, the significance of these cases is obvious, I think. Had the cases gone the other way, then employers who had been faced with the choices of either levelling up, making payments at the same level under the shared parental leave process as women got on shared maternity leave, or of levelling down statutory maternity pay, or enhanced maternity pay I should say, so that they could not be relied on as a comparison to improve shared parental pay. A number of our clients have elected to go with equal pay for shared parental leave and maternity leave, and that's obviously admirable. However, on the basis of the Court of Appeal's decision, it's going to remain something entirely at the discretion of the employer whether or not to take that step, because in the Court of Appeal's view it's not open to the disadvantaged men to bring complaints. I strongly suspect this is not the end of the road and that there will be an attempt to appeal to the Supreme Court, but let's see. Anyway, in headline terms, at the moment employers are able to continue paying differential rates for shared parental leave and statutory maternity leave period, and that's the case of Ali, Capita Customer Management Limited, Hextall and Chief Constable of Leicestershire Police. So next up, Tillman and Egan Zender Limited. Those of you remember the podcast I did 6 weeks or so ago with my partner Chris Fisher and Catherine Fox, a senior associate in the team, will remember that Mr. Fisher was asked to predict the outcome of this case, and blow me down, he got it absolutely right. The background was that Ms. Tillman had previously worked for Egan Zender in the executive search and recruitment business. She then looked to move, and a dispute arose as to whether or not her Egan Zender restrictive covenants were enforceable against her. The key covenant provided that she would not directly or indirectly engage or be concerned or interested in any business carried on in competition with any of the businesses of Egan Zender, which was carried on at the termination date or in the 12 months prior to that date, and with which she was materially concerned during such period. So just to flag it up, she must not directly or indirectly engage or be concerned or interested in. And the words that we want to think about are be concerned or interested in. Well, that's all relatively straightforward wording, you might think, but the point arose at the High Court stage, which has led to this going all the way up to the Supreme Court, as to whether this covenant is a valid covenant, because it was said it would preclude her from holding any shares whatsoever for the purpose of passive investment only in a competitor. In other words, someone would be engaged or concerned or interested in a business if they had a shareholding in it, and on the basis that there was no conceivable harm in having a 0.0001% shareholding in another company, that meant the covenant was too wide. So the issue arises, how is the covenant to be interpreted? Does it cover this sort of irrelevant minority passive shareholding point? If it did operate in this way, could the provisions be severed so that the undoubtedly valid bits of the restrictive covenant could survive? I want to focus on the severance point because I think that's the real significance of this case. By the by, however, we have a new contender for the oldest case to be mentioned on the podcast. Ladies and gentlemen, I'd like to refer you to Dyer's case in 1414, which is referenced in the Supreme Court in this decision. Mr. Dyer had apparently broken a condition in his contract that he would not work as a dyer for 6 months after leaving work for the plaintiff. The court found that the obligation was entirely void as a matter of principle, and the judge said, and I quote, "By God, if the plaintiff was here, he would go to prison until he paid a fine to the king," unquote. So, common law in its infancy there. Well, the issue with which the court was concerned in relation to severance was that the test for severance, which had previously been understood to apply, did not seem to permit severance in these circumstances. Remember, the wording of the covenant was, in a single paragraph, that the individual would not directly or indirectly engage or be concerned or interested in any competitor business. There was no exclusion, as I say, for the purpose of minority shareholding. So, if the court interpreted the phrase concerned or interested in as including the minority shareholding, was it permitted to delete the terms concerned or interested, whichever one was held to apply, from the larger single covenant? The generally understood requirements for severance prior to this case, in order to turn an invalid covenant into a valid covenant, are, of course, that a court cannot rewrite a clause, it can only delete wording from a clause. But in what circumstances can it delete wording? Well, according to the Atwood case back in the 1920s, the deletion, or blue pencilling as it's usually called, is only applicable if the covenants were capable of being treated as separate covenants. In other words, it was not enough that you could delete bits of the covenants and make grammatical sense after deletion. The covenants also had to be separate covenants. So, to take an example under the Atwood test, if there was a covenant that said you cannot work for a competitor in England, Scotland, Ireland or Wales, and it was unreasonable to have included Ireland, let's say, in that list, the Atwood case could have made it problematic for you to delete Ireland from the list, even though it would make grammatical sense, because it's not a separate covenant, and therefore the covenant would be too wide, and therefore you lost the entire covenant, even though the only problem was that it covered Ireland. Well, other cases, and in particular a case called Beckett, had taken a rather more easygoing approach to the circumstances in which a covenant could have words deleted from it to enable it to be valid. Well, basically the Supreme Court has decided there should be a more relaxed approach to the severance of covenants that would otherwise be invalid. The blue pencil test will continue to apply. The issue is whether or not the wording which goes too far can be removed simply by deleting wording. If the wording is deleted, i.e. still grammatical sense, if the wording is deleted, is there still adequate consideration for the covenants? Well, in an employment context, if the employer is saying it wants its covenants reduced to make them enforceable, it seems extremely unlikely, I think, that will ever be an issue. Well, thirdly, the deletion of the wording should not change the nature of the covenant so as to be something entirely different from what the parties entered into. Again, it seems a bit difficult to see how that might apply in an employment context if it is the employer that is seeking to remove some of the wording. I think obviously this is an extremely important case. You don't get Supreme Court cases on restrictive covenants every decade. I also think it's going to switch the focus of battle over restrictive covenants because, in practical terms, I think the court has made it easier to enforce restrictive covenants. My experience is that, by and large, most restrictive covenants these days are pretty properly drafted. It's relatively rare to come across something where you can be really confident that the drafting glitch means that the covenant will not stand up to a challenge at an interim injunction stage. Therefore, the focus is going to be on the facts rather than on the interpretation of the covenants, I think, in most cases. In other words, an employee's main argument to try and avoid the enforcement of restrictive covenants is going to be more fact-based. I was constructively dismissed, or this clause is wider than is necessary on the facts for the protection. Once the court accepts that it's easier to delete words out of a covenant if a bit of a covenant goes too far, I think we're going to see speedy trials and fewer interim injunction battles. It'll be interesting to see how this develops, but for now it does mean that employers are not going to have to go back and look at rewriting all their covenants so that there is a long list of separate covenants, the Atwood test, rather than mixed wording within a single covenant. So that's Tillman and Egan Zender Limited and the Supreme Court making the enforcement of restrictive covenants, in my view, rather easier. So, last but not least, Mr. Forbes and LHR Airport Limited. This is a really interesting case on social media and alleged harassment. Claimant worked as a security officer for London Heathrow. One of his colleagues, a Ms. Stevens, worked in a similar role. She had a Facebook account, and in November 2016 she put an image of a gollywog on her Facebook page and shared it with her Facebook friends. It didn't make any reference to the claimant in any way, but the claimant was subsequently shown this image by one of the original recipients of Ms. Stevens' Facebook posting, and the claimant was upset by the image and asserted that racist images were being circulated at the workplace. When Ms. Stevens was challenged, she apologised, but then she was rostered to work alongside the claimant. He complained. He was then moved to a different location, and he then issued proceedings in the tribunal claiming he'd been harassed, victimised and unlawfully discriminated against. Well, the Employment Appeal Tribunal upheld the original decision of the Employment Tribunal. The Employment Tribunal had focused on whether or not Ms. Stevens, when she put the image on Facebook, was she acting in the course of her employment. That was, I should say, is a necessary step for finding that the employer is vicariously liable, in effect, for the actions of its employees in the field of harassment, victimisation, etc. The Employment Appeal Tribunal pointed out that it's quite difficult with social media to know whether a posting is done in the course of employment. It may not be easy to say whether a person is doing something whilst at work, because work activity can be conducted online at home and a personal social media account may be accessed during employment. If the social media account is used for purposes relating to work, then the Employment Appeal Tribunal said it might be open to a tribunal to say that there was a sufficient connection to make the posting as being in the course of employment. But the EAT said, and I think must be right to say so, it wouldn't be appropriate to lay down any hard and fast lines. Here, the tribunal was entitled to take account of the fact that it was a private Facebook account. The image was shared among Ms. Stevens' Facebook friends, one of whom happened to be a colleague, who subsequently showed the image to the claimant. There was no evidence, that the image had been circulated at work. Therefore, the act had not been done in the course of her employment, and the Employment Tribunal had been entitled to come to that decision. So, no liability against the employer. The Employment Tribunal had, however, gone on to consider some other matters. They'd also decided that although the image was an offensive image, and the claimant was offended, nonetheless the conduct did not amount to harassment. So although the claimant was offended, genuinely, it was not reasonable for the claimant to be offended. In coming to this decision, the Employment Tribunal took into account that when the offensive nature of the image was explained to Ms. Stevens, she offered an apology and was agreeable to mediation. The Employment Appeal Tribunal said the Employment Tribunal had been entitled to take into account the apology as being part of the factual matrix in deciding whether or not it was reasonable for the claimant to be offended by this particular image. Well, I think that's an interesting step, given that you normally assume that whether or not someone was entitled to be offended would be dependent on the actions or omissions at the time rather than what happened subsequently. So I do think this does mean that it's quite important how an employer and the alleged poster of offensive material react when challenged. So the claimant here lost his case. And I think overall for employers it's a pretty helpful case. There's no doubt that social media posting and the risks of it are very much in the news today. And I think it's a relatively extreme set of facts. It's a private Facebook group. The image didn't seem to be circulated at work. The claimant did not allege the person who showed the image to him was themselves acting in the course of employment. But it's a useful reminder that the allegedly offensive posting of a comment needs to be in the course of employment before the employer will be responsible for the employee's offensive, wrongful posting. So that's the case of Mr. Forbes and LHR Airport Limited. So, thank you very much for listening to this podcast. Hopefully more normal service will be resumed, although I should say I'm going to be away for the second half of August. So, but let's see if we can do one between now and then. Anyway, in the meantime, as always, I would like to confirm that no employees were harmed or mistreated in the making of this podcast in any way, although one partner at Mayor Brown feels he's rather overworked at the moment. So, thanks very much for listening. Cheers.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.